How do you terminate a mineral rights life estate? If you are curious about how to terminate a mineral rights life estate, you are in the right place. This topic can be a bit complex, but let's break it down into simple steps. A mineral rights life estate is a legal arrangement where one person, known as the life tenant, has the right to use and benefit from mineral rights during their lifetime. Meanwhile, another person, called the remainderman, holds the future interest that comes into play when the life tenant passes away. The most straightforward way to terminate a mineral rights life estate is through the death of the life tenant. When the life tenant dies, full ownership of the mineral rights automatically transfers to the remainderman. This process does not require probate or any additional transfers, which makes it quite seamless. Another way to end a life estate is through voluntary termination by the life tenant. This means the life tenant can choose to transfer their interest in the life estate to the remainderman or another party before they pass away. However, this often requires the consent of the remainderman, especially if the life tenant wants to sell or lease the mineral rights. It is important to have a legal agreement or deed that clearly states the termination and transfer of rights to avoid any confusion. Merger of interests is another method for termination. If the life tenant acquires the remainderman's interest, both interests merge into full ownership. This means the life estate ends because one person now holds both the life estate and the remainder interest. In some situations, a court may also terminate a life estate. This can happen if the life tenant violates the terms of the estate or causes damage to the property or mineral rights. A court can step in to protect the remainderman's interests and order termination or modification of the life estate. Lastly, there may be specific conditions that can lead to termination. Although this is less common with mineral rights life estates, some arrangements may include conditions that, if not met, could cause the life estate to end. For example, if the life tenant fails to pay taxes or maintain the property, this could lead to forfeiture. When dealing with mineral rights life estates, it is essential to consider estate planning. These arrangements allow the life tenant to benefit from mineral income during their lifetime while ensuring that rights pass smoothly to heirs after death. Proper legal documentation is necessary for any termination or transfer to establish ownership clearly and prevent disputes. Keep in mind that laws regarding mineral rights and life estates can vary from state to state. Consulting an attorney who understands local laws is vital to ensure the termination process is handled correctly. Additionally, terminating a life estate may have tax implications, such as gift tax or estate tax consequences, especially if interests are transferred before death. In summary, a mineral rights life estate typically terminates upon the life tenant's death, but it can also end through voluntary transfer, merger of interests, or court order under specific circumstances. Understanding these processes can help you navigate the complexities of mineral rights and estate planning effectively.